we say it's confidential and you don't agree. In that very situation which you've described, we would have in our agreed upon protective order a way to handle that. And usually, I'll tell you, like, standard in my experience thus far is I might say I believe documents A, B, and C are confidential. And you might come back and say, Michelle, I'm not real sure about B. Okay, let's talk about it. Get on the phone. Say, all right, well, why do you think it is? Why do you think it's not? All right, how are we going to handle it? If we can agree at that point, great. If we can't, then there's a provision where we would go to either the judge or the arbitrator and say, hey, look, we got a disagreement here. We think it's confidential. Ms. Shields disagrees. What should we do? And then we leave it in their hands to resolve. So that way, we both have an opportunity to challenge whatever the designation is, but the ultimate decision maker is the decision maker, so that it sort of allows us to go through the channels, and we always make every effort to resolve it amongst the parties.
Okay, and that's understandable and agreeable. So email is out of the question for me because the email address has been compromised.
Okay.
So that's out of the question for me as far as the way to handle it. So I definitely would prefer telephone conversations or face-to-face meetings.
Okay, and that's really great to know, and I'll tell you, so much of our practice is commonly emails back and forth, so if that's not going to work for you, I'm glad we can get that straight now, just so we can avoid any future confusion over that. I believe I left you a message about initially trying to set this up. Did you get that message? I want to make sure I have the right number for you. Okay, good. So that's the proper number to reach you?
Yes, it is.
Okay.
Still looking for an attorney and wanted representation, so didn't have it, so didn't know what to do, so you got the letter.
Yes, very good. I understand. Okay, so I will make sure to note that. So I'll ask you some of my thought process, my questions about kind of nailing down some of the points we just talked about. So if we can agree that if either one of us has a good faith basis to say something's confidential, we would normally designate it as confidential. And by that I mean it's a typical process. When you label an exhibit or a document, you put confidential in the label if you believe it's confidential.
I've seen a lot of cases where when you get to the discovery stage of the process that most defense attorneys, most people just arbitrarily go in confidential, everything is confidential, and things are typically not confidential, but they just mark it as confidential as a way to keep it from the public. And I don't like that process at all. So I believe that things need to be, if it's confidential, if it's top secret or trade secret, whatever it is, it needs to really have some information contained in that.
Well, and you're absolutely right, and I'll tell you, federal judges hate that too. Judges of any kind, arbitrators, they don't like that. That's a misuse of the process, frankly. So we definitely agree on that. And that's where the good faith basis language comes in. That makes it the responsibility of both of us as the parties, as me representing the party and you as the party, to make sure we're not using that designation in a way that's inappropriate. And so what happens is typically anything that we believe, either one of us would believe contains confidential information, would be stamped confidential. It would still be given to you or still be given to me, but it would be stamped confidential. And that would be the first trigger where either one of us would say, wait a minute, I don't agree with you that that's confidential. And that starts our process of negotiating what to do about that particular document.
Okay, that's fine.
So I
can agree to that as long as we don't just go and everything that's submitted is stamped with a confidentiality sticker or stamp. So it definitely needs to be something that's confidential, and if you're designating it as a trade secret, I need to know what that trade secret is, and we just need to be truthful.
Absolutely.
Good faith is what you're using.
Good faith, yeah. That's our obligation as litigants to make sure we're acting in good faith for both of us on both sides. Typically, I will tell you, and just so we're clear, you don't typically stamp something with what it specifically is. Like, we wouldn't say trade secret, it would say confidential, and that would, in our protective order, it would define what confidential information includes. So it would be, you'd see a confidential stamp on a document, and then you go back to the protective order. Okay, is it personal information? Is it trade secret? Is it what? And you use those two labels and definitions together to figure out what it is, and then if it's not clear, that's when we start talking again about it.
Okay.
Does that make sense?
Sure.
And then anything that has a confidential stamp on it, what that means typically is neither one of us would disclose that to anybody else in the litigation or outside of the litigation. So we would use it, we'd have the information available to us, but as an initial premise, we don't use it we don't disclose it with anyone else.
Anyone whatsoever?
Right, and as an initial premise, okay, and that excludes, you get representation tomorrow, of course your attorney would see it.
But when you're soliciting for attorneys, people want to know what the evidence is and how strong is your case based on the evidence. And what attorney would you guys take a case if you did not know what the evidence was without having an opportunity to see what the what the basis or the merits of the case were? It's hard to get an attorney that cannot look at the evidence.
I can understand that. I think there's a couple of ways we can approach it. Discovery is an ongoing process, so even as people come to us and solicit representation, we typically don't have all the documents in front of us when we make a determination about representation. So I think there is some basis for believing representation can be obtained without disclosing confidential information. We can also come to some level of agreement about what could be disclosed in furtherance of your attempts to get representation. Because certainly nothing that we're talking about here today is intended in any way to prevent you from getting representation at all. It was just a matter of how we structure that so the confidential designations going forward the confidential information can be fully protected, but it wouldn't impede your ability to get representation.
To make sure.
Okay, I'm going to make a note of that. So, as an initial matter, can we agree that if it has a confidential stamp, we won't disclose it to anybody else outside of each other, and we'll work on an explanation for how it would be used in furtherance of representation for you?
And we must also know how is it. I must be able to clearly see, based on the list of what we've considered as what we're going to stamp as confidential, it must fall within whatever we've determined. So as long as that's understood, sure.
Okay. And the non-disclosure of confidential information includes public forums. So this is where we get into how we file things with the court, because the court's technically a public forum. If you wanted to have the judge consider a document that contains confidential information, there's mechanisms for how to do it. Right, you can file things under seal. Yeah, okay. So if you're willing to follow sealing procedures for filing in court, that's great. And then the court tells us how to do it, so it's...
Yeah.
Okay.
That's fine. As long as it's designated and fall within the
absolute
scope.
Absolutely.
Okay.
And so, in court, we will use, sealing procedures, and then the information wouldn't be disclosed in any other public forum. And any other...
And I just want to make sure going forward that I'm not agreeing to this based on... and so that you know what my intentions are, because I am going to go back and ask her to unseal those documents, because not all of them contain proprietary, top secret, confidential information. So we will be submitting a motion to unseal the documents, because a lot of the information is totally unrelated. Some of it is